I now request Dr. Shahnila Tariq, Assistant Professor, Department of Applied Psychology, School of Professional Psychology, University of Management and Technology, Lahore, Pakistan, to kindly present her paper. Madam, please.
Department of University of Management and Technology, Lahore. My topic for presentation is communication competence, self-control, and professional excellence in academic department heads. Uh, First, I want to introduce the variables. Communication competence enables us to understand others and communicate effectively in all social settings. Self-control is the combination of seven basic components like desire, conflict, preventive strategies, violation, control, motivation, opportunity constraints, and behavior management. It means if all these are present in a person, then the person has overloaded self-control. Then professional excellence. Professional excellence is recognized as the crucial professional success. It means if you are successful in your profession, whichever profession you are, it means that it is your professional excellence. The method which was followed for it was correlation research design, and 75 head of departments of the universities were selected. 38 HODs were from public universities and 37 from the private universities. 20 from the public universities were female and 18 male, whereas out of 37 private universities, 15 were female and 22 were male. Assessment measures, different assessment measures were used to measure the variables. Firstly, demographic questionnaire was also prepared, which comprised of age, gender, grades, number of siblings, birth order, family system, previous personal academic record also of the head of department. Then self-perceived communication competence scale was used, which was made by McCroskey in 1988. Desirability of control scale by Berger and Cooper 79. And then professional excellence scale by Tomar and Zeman 2013 was used. Uh, as the procedures follows for the academic research, same procedure was followed. And after taking permission and the permission letters from the concerned departments, appointments from the HODs was taken, and the consent of the HOD was also taken to fill the questionnaires. Also, most of the HODs, they just said they don't agree with the filling of the questionnaire, and they didn't give time. All the proper appointment was taken because all of the participants were the head of departments from different universities and different departments also. So the consent form along with questionnaire was administered. The questionnaires were administered in the presence of researcher. It took maximum 15 to 20 minutes to fill the questionnaire, and the participation of HOD was acknowledged on the completion of the questionnaire. The results showed reliability analysis, reliability of the communication competence scale, and was 0.6, self-control was 0.73, which was better than the other scales, and the professional excellence scale was 0.60. Next was the subscale of the self-control shows significant correlation between leadership and excellence, whereas well-being punctuality that was also significantly correlated. Critical professional excellence were also uh, listed, and you can see from the table that desirability of control was a significant predictor of professional excellence. What were the limitations and suggestions? availability of participants was very low as high rank population was approached. The head of department of any institute or any department or any academic department that it has many of the other academic as well as executive responsibilities. They were therefore they were very less head of departments who can be approached and who can be selected for the participation. That time that was the limitation. So next time there should be it's just a suggestion that next time that the second head of department or the senior most of the faculty member should also be included in the or the previous or the ex-head of department who are now retired. It should also be included and the data should be taken from them also. Then time for data collection was very less because it has to be completed in limited time. Because it's academic research thesis, so it has limited time within this semester system. They have to complete this research project. Therefore, they have limited time. It should be open time. There should be open time for the participants if that could be done on the greater or the larger population also. And qualitative method should be used and interviews should be conducted in order to get in-depth information from very successful and unsuccessful heads of the department so that we can compare, because it was just the quantitative analysis and quantitative the data was taken on the personages, the established personages, standardized personages. So it will be done by the qualitative method and interviews are in-depth interviews are taken, then it means that we can compare the results and the findings of the quantitative with the findings of the qualitative also, which can give a comprehensive analysis about the success and unsuccess of the participants or of the heads of the department. Implication to findings of the study is important for the heads and their colleagues to help them to understand how they can work efficiently in office and achieve excellence. So it is not only for the present heads, it can be the finding can be good for other colleagues also, so that they can help those heads also in order to make them understand that what is more important for them to work efficiently in their offices. So it will help heads to maintain hard headships for longer duration by improving their communication competence also, and it will be useful to gain professional excellence for potential individuals to focus intensively on self-control. It helps the academic heads to improve their excellence in their professional life and make them aware how people can be professionally excellent. So, not only the heads who are working at present, but it is also useful for the potential individuals, those who are at the highest level of their career, and there are chances that they will be selected within few years or within 1 or 2 years. They will be selected as head of department, so they can also focus on their communication skills and their self control. If they can have that control, it means that they can be very good professional. They have attained the professional excellence and they can be very good heads of the department. They can continue for the longer time also. Thank you very much.
We now request Dr. ANITHA HODLUR, Founder Director, Dakshinitya Arts Academy, Hyderabad, Telangana, to kindly present her paper. Madam, please.
All. This is Dr. Ratnakar. I have completed my diploma, degree, PG, MPhil, and PhD in dance only. And today's my topic is Dr. Uma Ramarao, the science of dance and superintendence. Dr. Uma Ramarao is one of the Kuchipudi Guru who has succeeded in making her space in the field of Kuchipudi dance, where only men were allowed to learn and perform the Kuchipudi dance. She was the queen of Kuchipudi dance. She was the treasure of science dance. She is the guru, guide, and philosopher to many generations. Her knowledge was infinite. Many dancers flourished in her superintendence. Her greatness was dwelling as a woman, a dancer, a choreographer, a researcher, a teacher, guru, as an administrator, and so on. Coming to her childhood, She was born on 4th July 1938 and named as Uma Maheshwari. Her father was Dr. Vaddadi Krishna Rao and her mother was Srimati Saubhagyamma. Here we need to mention one more person who was her uncle, Sri Vaddadi Babiraj Garu, who encouraged her during that time at the age of when she was at the age of 5. uh, he encouraged her to learn dance by knowing her interest in the dance. So in those periods, he faced many criticisms because he was encouraging girl child to learn dance. But in spite of all those situations, he encouraged her. Initially, he invited Sri Acharya P.V. Narasimharao Garu to teach her dance, and he used to came to their home and teach her dance. Next, when Padma Sri Nataraj Ramakrishna Garu came to Visakhapatnam, he invited Sri Nataraj Ramakrishna Garu to their home. He stayed there only and he used to teach her dance. When Nataraj Ramakrishna Garu observed that she is undergoing a very well training and she is doing very well, he thought that he should invite a traditional guru from Kuchipudi family and let her have training under his guidance. So he invited Sri Vedantam Lakshmi Narayana Shastri Garu to train her in perfect traditional Kuchipudi dance. So she undergone training of perfect Kuchipudi dance and she appeared even for the examinations of music and dance from the year 1953 to 55. Then in 1957, as her father was doctor, he started his practice in Hyderabad. So following him, the whole family shifted to Hyderabad. Then in Hyderabad, she continued her education. She has joined the intermediate with the science group. Then she has continued her dance and she even learned Bharatanatyam after coming to Hyderabad from Pakiri Swami Pillai Garu. So as she was learning dance, his father thought that better she would go to arts in degree so that it would be helpful to her field. Then again she has joined MA Economics. So she was continuing her dance along with her studies. In 1960, she got married with Sri Ramarao Garu. But she got actual problem there only. By then, she used to perform number of programs because she was learning very well, and along with her sister Sumati Kaushal Garu, she used to perform everywhere where major event take place. She used to get many invitations for the performance. But after getting married, she got the actual problem there. Her in-laws were not willing her to dance. They didn't like her to dance. So she has stopped performing from 1960. But her thirst for the dance was going on. She's chosen her career as a teacher, as a dance teacher. She was intended that her knowledge should not be stopped inside her only. She want to spread her knowledge. She just want to encourage girls into the field of dance, and she inspired many girls to learn dance. So from 60 to 61, she has joined music college as a lecturer, but as a Bharatanatyam lecturer, she has joined in Tyagaraja Music and Dance College at Hyderabad. But after 1961, she could not continue both the job and family responsibilities because she used to go for the music college in the mornings 7 to 9 a.m. and in the evenings 5 to 7 p.m. Those were the crucial timings for a family. So she left the job. She was looking after her family, but she was not at all satisfied. Again, in 1968, she has joined music college as a lecturer again, and she continued over there. In 1985, she has established Lasya Priya Academy, and there she trained n number of students. She has choreographed many solos and dance ballets. She used to take her children for all the major events for the performance in the state, in the nation, in international wide also. So she got fame as a guru because especially in those days women coming as a guru was very rare situation, and everyone were impressed by the performance of her students, and she became very famous. So in this process, In 1985, when Mr. N.T. Ramarao has become Chief Minister of Andhra Pradesh, he thought that he will establish a special university where fine arts and performing arts will have a special university. So she was joined region. One more thing I have to mention here. When in 1968, before leaving the music college job, the inauguration of Ravindra Bharati has taken place in the presence of President of India, Sri Sarvepalli Radhakrishnan Garu. So there, as a part of her job, she has to perform Chitrangada dance ballet. In that, written by Rabindranath Tagore. So she played Chitrangada role in the dance ballet in spite of objection from her family. But that was her last performance. Again, 68 she has joined. So again, come back to the point, when Mr. N.T. Ramarao has thought that he would have a special university, he invited Dr. Uma Ramarao Garu to come and hold the responsibility of establishing a dance department. So in 1987, she has been deputed to Telugu University from Music College as a lecturer. So she came to Telugu University. Initially, she had started a diploma course. Here she played a very major role of establishing a department for framing the syllabus and everything. So initially she had started diploma course, then degree course, then PG course also. So in this process, she has trained many students and she has choreographed, I think, more than 100 dance ballets she has choreographed, and her main target was girls. She encouraged, inspired, invited girls to learn dance. If we observe even today, each and every student is a jewel of Kuchipudi dance. They are spreading Kuchipudi dance everywhere in the world. So after coming to Telugu University, in 1994, she has completed her PhD on the topic of Shahaji Ekshagana Prabandhas, and she has been awarded gold medal for her PhD also. So this was a very happiest moment for all the women, who were learning dance, because in those times we could see very rare women learning dance. In 50s, I'm talking about 50, she has given performance and she has been struggling throughout her career, and 94 she could complete her PhD. So after that, she has for her remarkable contribution for the Kuchipudi dance, she have received many awards, and she has been awarded as the best teacher from state also. And in the year 2003, she has been chosen for the Central Sangeet Natak Academy, which was very prestigious award. Then into the dance department, she has also taken the responsibility of head of the department. She was head for the, and this is totally a complete responsibility. She was holding family responsibility. She was a teacher. She was a guru. She used to do Nattuvangam very well, which we could see very rarely in those days. And she rejoined music college. She came to Telugu University. There also she has given, main importance was teaching and performance only. But here he has taken the responsibility of administrator. She administrated very well. She holds so many responsibilities as associate professor in Telugu University. Apart from all this, she was an author also. She wrote many books on dance, which would be helpful for the upcoming generations to study theoretically also. So she wrote many books, and whatever her mind she has faced, she want to express to the next generation. She never hold her knowledge inside her. She used to teach. She used to spread her knowledge everywhere. Then surprisingly, on her 75th birthday, that was on 21st June 2013, she gave one more performance. That was a very precious moment for her and also for all of us who were her students. So at the age of 75, she performed, and that was her last performance. Coincidentally, Today is her death anniversary. She left all of us in the year 2016. So she will be always remembered in our hearts for her great contribution being a woman in the field of dance. Thank you.
We now request Dr. KOTLA Hanumantrao, Associate Professor, Department of Theatre Arts, Potti Sriramulu Telugu University, Hyderabad, Telangana, India, to kindly present his paper. Sir, please.
I'm Dr. KOTLA Hanumantrao, Associate Professor, Potti Sriramulu Telugu University. First of all, I'm very much thankful to IMRF and Red Talks International. My research topic is A Woman in Disguise, Muna Rayalu. I go through the paper. Surabhi is one of the oldest group belonging to Andhra Pradesh, India. This is the theatre group that mainly performs Padyanatakam, that means verse drama, with a history of 140 years. They hail from Maharashtra and settled in Sorgu village of Kadapa district in Andhra Pradesh. Surabhi was the first to introduce women playing women role on the stage, as till then both men and women roles are played by men. This open thought of Surabhi theatre introduced many exceptional talents to the world of theatre. One of the exceptional gifted talent among them is Srimati Jamuna Rayalu. The finest artist was born on 22nd January 1960 in Tenali, Guntur district. Banaras Kondalrao and Vasundhara Devi. She played the character of Lord Krishna's childhood when she was 21 days old. By the age of 8, she performed Harikathas and Burakathas brilliantly. She married her uncle Sri Aveti Krishnadevarayalu. She did her first performance as Lord Sri Krishna in the play Chintamani. She shared the stage with legends like Pispati Narasimhamurthy, Shanmukha Anjaneya Shastri, Vemuri Ramaya, and many more at very young age. This versatile actress performed male and female characters with grace. She portrayed the characters of strong women like Balanagamma, Gunasundari, Jhansi, Draupadi, etc. In 2012, she performed 60 performances in collaboration with Tirumala Tirupati Devasthanam. The play is Srimati Raigonda Vengamamba. She shared the television screen with well-known film director Vishwanath Garu in the serial Suryaputrudu, and she acted in many serials and television reality shows also. Awards and special recognition. She was awarded Paidi Lakshmaya Award for Best Actress, award from Potti Sriramulu Telugu University. She performed Satyabhama role in Sri Krishna Rayabharam in the presence of late Satya Sai Baba at Purvarthi. She was awarded Navaratna Mala, which is very precious. She received first Akkineni Nageshwar Rao gold medal from Nageshwar Rao. She was inspired from Kuchipudi dance, Ardhanarishwaram performance, where the dancer dances both male and female as Parvati and Shiva. She was greatly inspired, and she, for the first time, performed a mono action in which she was dressed as both Lord Sri Krishna and Satyabhama. She introduced this type of act for the first time in verse drama and was awarded with Golden Bangle and Silver Flute. She was given the title of Padyagana Sampragni, meaning Queen of verse drama. She was indeed a queen with full of self-respect, independence, and love for others. One incident of this is during Nandi competitions. In spite of her remarkable performances, the Best Actress award was given to some senior due to some pressure at the time. Gummadi Venkateshwara Rao, late Gummadi Venkateshwara Rao garu, veteran film actor. He was the jury member. He impressed by her acting and decided on giving the prize money to her personally, as the award cannot be shared. He rejected the cash prize. She always thought award was more important than the money. She rejected the award, saying that she will not accept the money when the award is not under her name. Such was her self-respect and passion towards acting. In my research about getting to know Jamuna Rayal Garu, I interviewed three of her close associates. One is co-actor, is a famous Padhanatakam artist, a former Andhra Pradesh Sangeeta Nataka Academy chairman, Gumadi Gopalakrishna Garu. In his words, they performed many plays together for nearly 10 years. She gave her best, even if it was a contract play, or amateur play, or Surabhi play. She was the rarest Surabhi person who was into teaching. She did many acting workshops for many children. She had modern thoughts and she performed in many experimental verse dramas done by many non-Surabhi members. I interviewed writer, director, Mr. Deepika Prasad. He said that they were associated for more than 30 years. He said she had physique which made the character come alive when she performed. She did not have in singing knowledge, but always caught the director's approach to the scene. She could sing in three stages, Mandara, Madhya, and Tara. The three stages she can sing. At that time, only Ghantashala Garu could sing. She never was particular about the remuneration. If the character and scope of acting was more, instead of being professional, she encouraged newcomers. And the third one, I was interviewed, that is Venu Gopalachari, is an harmonist. In verse drama, there were always high pitched tones. He used soft bani. She could sing at the pitch of down. She modulated her voice according to the character. She changed her energy and voice according to her male and female characters. Jamuna Rayal Garu ruled the contemporary theatre of mythological plays. Was a kind and a good human being. A strong woman stands up for herself, but a stronger woman stands up for others too. She was the best example for it. She helped the needy with their daily needs during the global pandemic. In this course, she was affected with virus. Her condition worsened and passed away on 22nd of August this year. A woman is full of a circle within her is the power to create, nurture, and transform. She created her mark in the field of verse drama, nurtured her talents, and transformed into a brilliant actress who will always be remembered. May her soul rest in peace. Thank you very much.
We now request Miss A. Arsha, Faculty in Law, Miss Aishwarya Murali, Faculty in Commerce, SCMS School of Technology and Management, Alluva, Ernakulam, Kerala, to kindly present their paper. Madam, please.
A very good evening to all. Respected dignitaries, Chair, and all the listeners. Myself, A. Arsha, and my colleague, Ms. Aishwarya Murali, will be dealing with the topic electronic judicial system. And this, how we can access this justice in this virtual world. To give an introduction about ourselves, I am a lawyer by profession. I completed my post-graduation in law and I am teaching law in SAMS School of Technology and Management. And my colleague was Aishwarya Murali is a postgraduate in commerce as well as business administration and is dealing with the topics commerce as well as information technology papers in our department. And we jointly had a discussion about this topic of electronic judiciary because even right now, what is happening in this judiciary because of this pandemic situation, even judiciary has turned out to be taking in justice or giving justice to people in an electronic manner. And this is a humble suggestions are there from our side, wherein things can be made more electronically so that the judicial system can be brought in a faster manner without any time consuming and being user friendly. So it'll be a combined presentation wherein I'll be dealing with the introductory sessions and it will be continued after by Ms. Aishwarya Murli. So to begin with, you can see what was told in by Aristotle. Okay, Aristotle told in that all the virtues, okay, all the virtues are to be brought to justice. All virtues are to be brought to justice. It means we have to get in justice. Justice is mandatory to be served to every individual. That's mandatory. Justice can be denied, can never be denied. I'm sorry. Justice can never be denied to any person. It may be delayed, but the delay will cause a huge harm to individuals. So there are suggestions from our side how to avoid this delay which is happening to justice to be received by people. Before going into that, we'll just go through what was a judicial system or at how justice was administered in our country throughout from the ancient India. So, as an introduction, we'll get to know what actually is justice. The term justice, as such, was derived from the Latin word justitia, which means just bound or to tie, where people are joining or fitting together to get what is the need, what they actually need. And this concept of justice has been analyzed and defined by various schools of law, the sociological, the psychological, various aspects, various jurists have defined it in different manner. The judicial system has been defined. And what has been stated by them is there has to be a harmony between them. Harmony is required, it's mandatory. And this administration of justice, when you given justice to persons, you have to take into consideration various aspects, the moral side, the social side, the economic side, everything has to be taken into consideration. And it plays a huge role. And now, moving to the different periods, how justice was administered with the ancient India. When we take the ancient India, we can say the judicial system was very much codified because there was even legal literatures. We can find legal literatures over there. Even the complex situations were given in the legal literature. We had, as in the Arthashastra written by KOTLA, to be the basic rules of the society was formulated in that. And justice was mainly given to individuals, irrespective of any kind of social or religious life. It was in an equal manner. That means we had a centralized administration of justice in ancient India. And even you can see that the judicial system which was followed, even before the concept of the theory of separation of powers began to be developed in the world, we had that to be followed in our country, in the ancient India. And the criminal courts was also there to deal with the various types of offences, and the civil, be it be the criminal offences. Even in the panchayat levels, there were people to look into that affairs. That's about the ancient India. Now, when we move to the medieval India, what actually happens is, in the medieval India, it begins with the advent of the Mughals. And the Mughals, as such, were considered to be the ones who were considered to be the lovers of justice. And they had they had this love towards justice, that they had courts to be established, and things were established from the courts, from even things were adapted from various countries like Arabia, Syria, Persia, Egypt, etc. And the foundation of the justice, as well as the final person to whom we can go in for an appeal, was the Sultan or the Emperor. And the judicial system was so open that all matters, be it be the civil or be it be the criminal, everything was decided in an open court. And the final matter was always heard by the Emperor. The final word was by the Emperor. And the major thing is, even if you want to give in a death punishment, death penalty, it was not easily possible. How you had to give in the death penalty, it was only on the basis of a third time Only the third time you had the emperor saying, okay, you have to hang that person. Then only then the death penalty was awarded. That's how the capital punishment was also given. So everything had in a writing how things are to be codified. So we know that every twice a week, the judicial system, courts was met and decisions was taken mostly in Friday. So there was no delay even there. And there was no distinction too. I don't say that right now we have a distinction, but still in the medieval India, there was no distinction between the secular and the common law. Now, moving ahead with how we had the judicial system in modern India. There is a separation right here, prior to the Britishers and after the Britishers. So, prior to the Britishers, what we had in that, it was considered that how the judiciary decides matters always add to the value of the state. But after the Britishers left in the year 1947, they left our country and India became independent. We started steps for drafting our Indian constitution. And then we have the Indian constitution in force. And this Indian constitution was drafted under the leadership of Dr. B.R. Ambedkar, and it followed the principle or the theory of separation of powers, which told it there has to be separation between the three organizations: the legislature, executive, and the judiciary. So the judiciary has an independent, free, and independent role. Nobody interferes into the affairs of the justice or the judiciary. Now we know that there is a hierarchy for dealing with matters. For every aspect, there has to be a hierarchy. There is a chronology, how things are to be dealt with. So how is justice being administered in our country? Okay, so there is a uniform system, where we have to approach, things are being decided in that manner. So the hierarchy, the hierarchy is in this manner. We have the Supreme Court, which is the apex court. And then we have the high courts at the state level, then the various district courts and the specialized tribunals as well as the lower courts. So this actually is a hierarchy. So this hierarchy, a common man may find it to be very complex. They may not know. But what has to be ensured is like right now in all the Supreme Courts as well as High Courts, we have a justice system which is being prevailed. They have going for the electronic way of settling out or administering the justice right now in the COVID pandemic situation. Matters are being heard online. Right now we are meeting and we are having this webinar through Zoom as a platform. Even courts, even here in Kerala, the Kerala High Court decides matters which need to be settled out through Zoom. So, isn't it mandatory or isn't it good that we adapt to the electronic judiciary so that things can be made easy for all the stakeholders, everyone who is related to the court? So, we have found in that, we have started to have it, or we have tried to bring in some suggestions for developing an electronic judiciary. So that's mandatorily needed. It is needed. So from this on, we'll try to have in the suggestions. So from now on, the suggestions as to what is electronic judiciary and the continuation of it will be dealt by Ms. Aishwarya Murthy.
Good evening, everyone. So today, we are going to discuss about what is a e-judiciary. So we know the words which have a prefix E is something related to ICT. So in the case of a judiciary system also, since it has a prefix E, that is also related to ICT. So now, when we hear about the term ICT, we know that it has three words in that: information, communication, and technology. So first, let's see how all these three words are related with each other. So first, let's see what is information. So we know what is information. information is something meaningful that can be interpreted by any person. So, what is communication? Communication is exchange of ideas. And now we have one more word called technology. So let's see how all these three are integrated. Without the help of technology, if you are communicating the information to somebody, that is called information and communication technology. So we have different types of ICT tools that are being used, and that enables efficiency in work to some extent. So now, coming back to our topic, that is e-judiciary. How ICT is related to our judiciary system. So we know that in almost every aspect of human life, internet, information and communication technology, everything has a great impact. We know the government have now moved on to an e-governance system wherein all the activities which are conducted by the government has moved on to an ICT based system. So we know, like in the previous time, if we had to file an application, we had to write it, we have to go to the which is a section which is in charge of that, we have to wait for a long time. But now the situation is not like that. Whatever things you want to apply for, whatever queries you have, whatever things you want to convey with different authorities, everything can be done by a click of a button. So in the case of a judiciary system also, we suggest that if ICT tools are introduced into the judiciary system, that will help the judiciary system also to become more efficient. So let's see what is a e-judiciary. So when the information and communication technology, when that is introduced into an e-judiciary system, that is called e-judiciary. So how can we include an information and communication technology into a judiciary system? So let's see how we can include that. So next, we are moving on to a concept called e-courts. So all of us know what a court is, but now we are moving on to a concept called e-court. So as I told you earlier, since this also has a prefix e, that also must be something related to ICT. So here, it said that the courts can take the assistance of information and communication technology tools that will help them to conduct their court proceedings more easily and more efficiently. So it said that if there is a proper system which is an ICT based, like in the case of a software, or a central data repository which is used to manage all the data related to courts, that will help them to manage the data more efficiently, or it will help them to carry out their functions more efficiently and more easily. So in that way, we can reduce the number of cases which are getting mounted. See, uh, we don't have to waste time in getting all the paper printouts. We don't have to wait for some other people to write down the points that you have to say. So in that way, you will be able to reduce the paperwork. All and each and everything that you have to convey, that can be substantiated with the help of audio visual tools. So that in turn makes the court proceedings easy as well as efficient. So that way, you will be able to reduce the number of mounting cases. And we know that the current system, now due to the pandemic, we have moved on to an e-court system, but not fully. We know that the court proceedings are time consuming and cumbersome. We know that in movies and all, we have seen that some people, they give some litigation and they have to wait for years to get justice. So what happens is that kind of a system will make people so fed up. They will feel so frustrated and they will lose their they will feel like nothing is going to happen with such kind of a system. So under an ICT based e-court system, everything happens so fast, everything can be managed so efficiently that gives a time period within which it can be solved, a less time period within which all the things can be solved. And when everything gets solved very easily within a less period of time, that in turn reduces the backlog also. Now, if you have an ecosystem wherein the information and communication technology is introduced into, that makes the court proceedings transparent and that helps in giving a speedy justice to the litigants. And A smart litigation system should be there. See, in certain countries, they have a system wherein all the details related to how you have to file a litigation. If you have a case to file, whom you should approach, what are the proceedings that you have to follow for that. All these things are updated in a website. So under such situations, the litigants finds it easy because they know whom they have to approach, because they are accessing the website and they go to the website and they will be able to make out whom they have to approach. So what are the proceedings they have to do? So that kind of a system makes the e-court proceedings or the e-judiciary system more transparent and speedy. Next, let's see who are the stakeholders in Indian judicial system. So the most important person, the judges. These are the people who give judgments. So what is the role of a judge and how it can be connected to an IT-based system? So we know everyone is aware about the role of a judge. So now let's see what is the use of ICT for a judge. We know that there are different case laws and there are different judgments related to different cases. Now, if a case comes to a judge, what he will be doing is, before giving the judgment, he will be just going through the previous judgments in similar nature of cases, similar kind of cases. He will be just going through the judgments which were given earlier. Now, normal situations, what people do is you have to go through different journals, they have to go through the library, they have to go through the different books that they have with them. So, in under such situations, what happens is it becomes a lengthy procedure. They have to sit up and they have to go through, they have to spend a lot of time to see what the judgment is. But if we have a e-court system or e-judiciary system, all the judgments related to a specific category of or specific similar nature of cases can be stored at a single place or under a single tag. Such kind of cases can be stored. So when a person, when they click on a specific option, they will be able to list out all the related judgments related to a specific kind of a case. So under such situations, the judges will be able to save a lot of time. And in addition to that, we know that whatever things the judgment or whatever things that they do while in the court, whatever they say, everything is recorded by a steno. So under such situations, there can be certain situations that some words can be missed out by the steno. So under such situations, it was very difficult for them also. So here, what we can do is, if there is a e-system, the judge can directly record the voice that they are while they are giving the judgment, and under such and by that way, they will be able to save the time. And as far as a legal professional is concerned, what is the role of ICT? See, the legal professionals also, see, when we hear a legal professional, what comes into our mind is a person wearing a black coat who carry lots and lots of files with them. If there is an ICT based system, the legal professional does not have to carry lots of files with them, because they just have to carry a laptop or maybe a pen drive wherein all the required resources for their work is stored in. And the legal professional, then they have some points to substantiate. They will be able to use audio and visual tools with the help of presentations and all. They will be able to substantiate their point more efficiently. And the next, in the case of the court staff, the court staff also, they do lots of clerical work. So if they have an ICT system or a computer or any database system with them, they will be able to enter all the details related to that. And if they have some court fee associated with any transaction or any litigation, they will be able to access that with the help of a computerized system. They don't have to do it manually. And as far as the litigant is concerned, see, suppose if there is a system wherein all the details related to a litigation is entered into a database or a website, the litigants will be able to understand, or they will be able to make out what is happening with their case that they have filed. What is the status of their case? If their case was like taken for discussion on a certain date, on such date, if they were not able to go physically to a court, what happened actually in the court? What is the judge's decision regarding that case? All these things can be updated into a website wherein the litigants can view that from their system. And in the case of an investigation officer, see, under such certain situations, investigation officers will find it difficult to bring the accused to a court of law. So under such situations, if there is a video conferencing facility, what happens is it makes it easy for them to have the interaction, like the interaction with the judge or the legal professional with the accused can happen through a video conferencing. And under certain situations, we know that certain cases requires in-camera proceedings, and there are certain litigation which is having a confidential nature because we need to protect the confidentiality of the case, or maybe we need to protect the interest of the victim. So under situations like that, we can go for a video conferencing system wherein the confidential nature of the cases can be protected. And as far as the general public is concerned, if there is an ICT based system which helps a speedy procedure, the processing and all, if it happens very speedy, the general public also will have a confidence in the judiciary system. They will have a feeling that, see, everything gets sorted very easily. Everything is ICT based, everything is web based. Whatever happens is very easily visible to us. So in that way, the confidence that they have in the legal system can also be increased. And the next one, what is the future of Indian judicial system if we have an e-court system? We can say that paperless courts can be implemented. So what do you mean by paperless court? A paperless court is wherein all the details related to litigations, all the details are digitalized. And the next one, audio-visual presentation facility. So we know every aspect of human life now ICT is being used. So under the judiciary system also, if an advocate or if a legal professional has something to present, that can be presented with the help of an audio-visual presentation facility. So that way he will be able to do his work more efficiently. And the next one, as like video conferencing facility, as I told earlier, we have situations wherein the confidentiality of the cases have to be protected, or under certain situations, the person might feel difficulty in appearing before the court of law physically. So under such situations, we can go for a video conferencing facility. Next, we have a e-advocacy. So under e-advocacy also, what we can do is, if there is in-camera procedures required, we can go for e-advocacy, e-filing of the cases, which helps the filing of the cases through websites and all. And the next one, e-stamping. So we know the use of stamp papers or stamping, what it is. So under such situations, that can be done through a computer system wherein it can be saved in a tamper-proof format. And next, we can have a facilitation center also. With the help of the facilitation center, what we do is, we will have a certain kiosk installed in certain locations inside the court, wherein people will get the status on what is happening inside a courtroom. Is the next case which is going to be discussed, is it their case? And as far as an advocate is concerned, this facilitation center or the kiosk facility will help them make out, is it their case that is going to be called next? So all these things can be done with the help of a facilitation center. And next, what are the benefits of e-court? See, if you have an e-court or e-judiciary system, it gives an efficient court management. The documents, whatever documents we have to maintain, that can be digitally maintained. Speedy disposal of cases. Justice is served. We can say that timely judgments can be given and the case can be closed very easily. And internet aids are available for citations and research. And if any judgments are made or if their cases are closed related to such details, it can be mailed to the concerned parties. And congenial and comfortable atmosphere increases efficiency of the work. So we suggest that the e-judiciary system will increase the efficiency of the courts as well as the judiciary system. And that in turn helps to solve many issues associated with the judiciary system as we see it now. Now, almost all of us are aware that due to the pandemic situations, almost all the courts are doing their activities through ICT-based systems only. But what we suggest is that this can be continued. That in turn will increase the efficiency of the court. So that's all. Thank you.